Good morning. We're on the videotape record beginning DVD 1. This is the digital video deposition of Cynthia Hernandez-Buter testifying in the matter of Duval versus County of Los Angeles, cause number BC 470714. This deposition is being held at Atlantic Aviation, 2828 Donald Douglas Loop North, Santa Monica, California, 90405. Today's date, March 31st, 2016. The time, 10:45 a.m. My name is Matthew Housley, Legal Video Specialist with Jordan Media Incorporated, 1228 Madison Avenue, San Diego, California. The certified shorthand reporter today is Jan Roper with Crown Court Reporting. Counsel, please state your appearances for the record.
Sean McMillan appearing on behalf of the plaintiff, Rafaelina Duval, and Travis Cox from my office is present with me.
And will the court reporter please swear in the witness?
Would you raise your right hand for me, please? You do solemnly swear that the testimony you're about to give in the cause now pending shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, good morning. Ms. Buter, can you state and spell your full name for us?
Yes, Cynthia Hernandez-Buter, Cynthia C-Y-N-T-H-I-A, Hernandez H-E-R-N-A-N-D-E-Z, Buter, B as in boy, U-T as in Tom, E-R.
Okay, and when we're speaking today, how should I address you? Should it be Ms. Buter, Ms. Hernandez-Buter? What do you prefer?
Ms. Buter is fine.
Ms. Buter is fine. I appreciate that. All right, Ms. Buter, you are here today pursuant to a subpoena to appear personally for deposition. You understand that, correct?
Yes.
And it's also your understanding, isn't it, that the deposition today is sort of a continuation of an earlier subpoena that was served on you, I don't recall the exact date, but sometime in March 2015?
Yes, you are correct, counsel.
And in that, or in response to that deposition subpoena, you were designated as the person most knowledgeable to testify on behalf of the Superior Court?
Yes.
Okay.
Los Angeles Superior Court.
And specifically, it was Los Angeles Superior Court Juvenile
Dependency.
Juvenile Dependency. And just so that we're clear, you understood when you got that original subpoena to appear and testify as the person most knowledgeable that because of the designation by the court of you as being the person most qualified to testify, you needed to undertake some steps to familiarize yourself with the material that we were looking for in that deposition?
Yes, counsel.
Okay, and what steps did you take to become knowledgeable about the matters that you were going to testify about?
I had some familiarization with the removal order process as an Administrator 1 who was assigned to the Juvenile Dependency Court in 2010 when the process was implemented. I was an administrator who had oversight over some clerical functions and some courtrooms, and my colleague was actually, Reggie Papachon, was actually the administrator at that time that was directly involved with the removal orders, but when he wasn't available, I had to have some knowledge about that. And then in 2011, I became the dependency administrator, so then I had more knowledge about it. In order to prepare myself for the deposition or the meeting that we had last year, I reviewed our statistical information. I went and pulled up the procedures and protocols that were created by our then presiding judge, Michael Nash, and I just familiarized myself. I also met with our clerical staff who on a daily basis receives the removal orders and provides a clerical function. We log them and deliver them to the courtrooms to our judicial officers and conform copies and So that's what I did.
Okay, other than speaking with, now correct me if I'm wrong, but I believe his name was Brett Bianco, is that right?
Brett Bianco is court counsel.
Okay, is he the attorney that appeared with you? Because there were two attorneys that appeared besides myself and Mr. Park at our last meeting, right?
Yes, the only person that was sitting with me that is a court employee who is our court counsel is Brett Bianco.
Okay, that's what I thought. So Brett Bianco was with you at that meeting where we all got together, and he was the attorney that represented you and the court?
Correct.
Okay. There was also another attorney present there. I believe it was Kelsey Now. Do you recall that?
Yes, I believe, yes. And I believe she was a county counsel, or at the time I thought that's what she was.
Okay, but you understood, or you understand today, that she actually represents the county in this litigation?
Yes, sir.
And she does not represent you or the court?
Correct.
Okay. In fact, the court, and you may or may not know this, just tell me if there's something at any point in time where I ask you a question and you either don't recall or you really don't know the answer.
Sure.
It is perfectly acceptable to just say, I don't know.
Okay.
So just let me know that and we'll work around it. But do you know whether the courts are a part of the county government or the state government?
We are state funded, but our benefits are tied to county. But we are state funded, yes.
That's interesting. So
We went to trial court funding, and I can't remember what year in 2000, and so we are actually state employees.
Okay, so your paycheck is from the state of California,
It
not
is.
from the county.
Yes, correct.
Okay, so you truly are independent from the county government.
Yes.
Okay. Prior to our meeting last time, did you have any direct conversations with any county counsel, whether they be private retained or county government?
Related to this case?
Yes.
No, counsel, no.
Okay. What about after our meeting last time? Did you have any conversations with counsel?
No.
Okay. I'm going to show you what we will mark as, I guess, exhibit number 1. It's a multi-page document. I'm not going to count it. It looks like about 28 or so pages. But it's titled Declaration of Cynthia Hernandez-Buter in opposition to Defendant Balaban's motion for summary judgment, or in the alternative, motion for summary adjudication. And she'll mark it and then she'll give it to you. Now, before we get into that, we can go through a little bit of background. I'll try and do it as efficiently as I can. Based on what you said here in your declaration, it looks like you, at least at this time, or that time, rather, April 2nd, 2015, you'd been working for the court for about 25 years?
Correct, sir.
Okay. How much of that time did you spend with the juvenile court?
On and off throughout my career. I started as a judicial assistant, so I worked in juvenile dependency probably as a judicial assistant for about 6 years, and then I left to perform other duties in the court, other jobs. I returned in 2000 as in a promotion as, at that time it was assistant division chief was the position. I stayed for about a year and a half. I received another promotion and I was reassigned to the IT division of the court as a data processing manager. And then I returned to juvenile in 2004 or 5. Again, at that time, my item had changed to Administrator 1. And so I've been there in juvenile dependency at Children's Court since that time. I was promoted to Dependency Administrator in 2011. And I'm sorry, I don't know how many years that is. It's a lot of years.
Okay, so let me back up a little bit because that's a lot of information for me to kind of digest. So you said at first you were a judicial assistant for about 6 years.
Correct.
Was that at juvenile dependency?
It wasn't juvenile dependency. It was when we were not before children's court. So we were at the CJC Clara Shortridge building. And then we had a satellite court out in Van Nuys, which I worked at as well. And then in 1992, when Children's Court opened, I was reassigned to that court location.
And when you say Children's Court, that's the one out
Edelman,
at
Edmund D. Edelman Children's Court in Monterey Park.
Okay. So you've been at Edelman since 90. Well, no, you were at Edelman from 92 until
I
when?
think I went back around 2006.
Okay, so 2006.
Somewhere around there to the present.
Okay, and you said, I guess you were gone a little while from juvenile dependency because you'd said that you returned in 2000 as a assistant division chief. Did I get that right?
Correct. I did. It was a promotion. I stayed a little over a year, and then I was promoted into the IT division of the court.
Got it.
We were
Okay.
looking to develop a case management system, and I was a subject matter expert.
Okay, and the data processing, when you got or promoted to the data processing unit, was that also with the juvenile court?
No, I was working on a case management system that we were developing statewide. And then when the .com industry went down and we lost funding, and then I became the data manager and I had business analysts who supported the juvenile delinquency and juvenile dependency areas of litigation. But from an IT perspective, we supported their case management systems.
Okay, explain that a little bit to me. What does that mean when we're talking about their case management system? Was that the CWS CMS system or some other system?
No, that's DCFS or county system.
Okay.
JAI, Juvenile Automated Index System at the time, and JADE, the Juvenile Automated Data Enhancement, it's a minute order system.
Okay.
So when they needed to make updates to tables, language changes to minute orders, be able to incorporate a change in business process that we wanted to be able to track so that we could create reports, that was my staff that did that. We met with the operations people to determine how to make these changes.
Okay, and JAI and JADE, J-A-D-E,
Correct.
are those two different systems, or are they?
Correct.
Okay. And JADE, I think you said, was a minute order?
It's the current juvenile dependency minute order system.
And what is JAI?
It's a legacy mainframe system that has a register of action, that provides the ability to do case initiation. So it's...
Does it, do they still use it, or is that was something, you said it was a legacy system?
We do. We are in the works of developing a new system, and so in February of 2017 we'll move off those older systems.
So you'll be moving off
of JAI and JADE.
Okay.
Into Odyssey.
Into Odyssey. And is that also the court's own system that the court has developed, or is it?
No, it's a package system, Tyler Technologies.
And what about JAI and JADE? You said that you worked with like a group or some sort of
yes,
unit?
Well, those two were also the county ISD programming department actually developed those systems for the court.
Okay.
And then I, as a data processing manager, worked with the operational staff for both juvenile areas when there were necessary changes to those systems.
Got it. And necessary changes, those, I think you talked a little bit about this.
Legislative changes in law, we need to incorporate new findings and orders, add information to tables. We want to collect new data, so we add data fills. Okay. So I had some programmers under my direction and some business analysts.
Okay, and the programmers, those would have been supplied by the county?
Some, and some were in-house.
Okay, so you had some of your own people. example?
Yes, we did, because we had developed some in-house simple access type applications to help in some of the operational units
Okay.
in juvenile.
Okay, and you'd mentioned earlier that, I don't remember which one it was, whether it was JAI or JADE, or maybe both, that from time to time you would want to track certain data or something like that, and then you'd go in and write another, or have one of the programmers write an application for that purpose?
Correct.
Okay, what sorts of data tracking are you talking about?
We looked at filing petitions, how many petitions are filed, how many dispositions, reports, like why cases were continued, for insufficient report notice, those kinds of things.
So you were able to actually sort of drill down into some of the data that was accumulated to get very specific information?
Yes. Yes.
And who was it that would make the decisions, or the requests, I guess, to get certain data or certain statistics out of the database?
We have to be in compliance with state. We do reporting to the state, and I wish I knew what the acronym meant, but it's GIPSs. There's every court in California has to provide data to the state on filings and dispositions, because our funding is derived from the statistical data that we provide, and the number of judicial officers that are assigned in any to any county is also based on the numbers received. So it could be executive management, it could be judicial officers. My presiding judge might want to look at how efficient we are and what our filings are. Finance may want to look, because we need to hire more staff.
Now the data that you would report to the state, I think you said part of the purpose for that reporting was tied to funding, because the courts are funded by the state of California, right?
Yes, counsel.
And the juvenile court's no different, I guess, in that regard from any other court, right?
No, right.
Okay. The data that you would send to the state relative to what was going on in the juvenile court, would that include, for example, filed petitions, the dispositions of those at various hearing stages, that sort of thing?
Definitely the number of filings and of what type of petitions, and disposition information. But we have a whole separate, we are a large court, so we have a whole separate division that deals with statistical data.
Oh.
And so they put in requests as well as to what were required by the state to provide with information.
What division is it that deals with the statistical data?
Wish I knew exactly the name. It has to do, I think it's Statistical Management Unit. It's changed its name over time.
That makes sense. Statistical management unit, that's pretty self-explanatory. Was it a statistical management unit specific to the juvenile court, or was it countywide?
No. Yeah, court,
Okay.
countywide. Los Angeles County Superior Court wide.
Okay.
We have to provide that data for every litigation: criminal, family, probate, civil.
Now, at some point, and correct me if I'm wrong on this, I haven't gotten into the declaration yet, this is sort of just from general memory from our last conversation, but at some point in time, the court itself started tracking warrant applications, the juvenile court.
That is correct.
Do you know if that statistic is something that can be mined out of the databases for JAI or JADE?
No, sir. That was something that we track manually on an Excel spreadsheet.
That sounds like very intensive.
Yeah, it is not in our case management database.
So explain to me the process now, how you go about tracking warrant applications and the outcomes of those applications.
So on a daily basis, we receive these removal orders from county council. There are 2 designated times. 11:45 in the morning is the first batch that we receive, if we are going to receive any, and then at 3 p.m. in the afternoon we receive them. They come to my clerk's office. I have an employee dedicated just to processing them. From 2010 to now, we track, I want to say, over 5,000 a year now. When we started, it were hundreds. Yeah. So it's a full-time job for one of my employees. So we have a log to track and make sure that everything that is listed on what County Council says we received, that we actually received. We verify that there are the correct number of copies. And then we verify whether or not they are a regular removal order or if they are expedited. If it's an expedited removal order, to us that means that it needs to get to the judicial officer and signed the same day, by 4:30 or 5 the same day. If it is not expedited, that means we have 24 hours, so we have the next business day at 5 o'clock to get it completed. My staff then, after reviewing that, delivers them to the judicial officer who will be reviewing the removal orders for that day.
Okay.
And then we wait to hear from the judicial officer or the judicial assistant that they've been reviewed and signed, that they've been file stamped and conformed. And then my staff goes up and picks them up, my employee. She brings them down, reviews them, makes sure they're in the proper order, that all the stamps are in place, and then the county council, a representative from county council, comes and picks up their copies.
Okay. Now, you guys also do telephone warrants, right? Somebody can call in and get a warrant over the telephone?
The only ones that I am aware of are the investigative warrants, and those are heard by our supervising judge. And yes, I believe that a social worker is, I believe, sworn in over the phone, and the judicial officer takes the statement.
Okay, and but that's, as far as you know, that is only for investigative warrants, not removal warrants.
Correct.
And you'd said there were, it looks like, 2 different types of applications. One was the regular application, the other's expedited?
Correct.
Why is that? Why is there 2 different types? If you know, you may not know.
The only part I understand, I'm sure there's some legal reason behind it, but our understanding is that one needs the signature of the judicial officer, needs to be reviewed that day, same day, and the other one is not at the level of that emergency, and we have 24 hours to process.
That just seems weird to me, because if something is serious enough to seek court intervention, why would we wait? Why would there be a delay? That's where I'm having a little trouble.
I don't know. I'm not the person who would have that answer. I'm sorry.
Do you know who would have that answer?
I'm sure my presiding judge, my supervising judge.
They may or may not. It might
right,
just be
county
policy
council might be. Yeah, I'm sure.
Okay. All right. Going back to your data logging. This is interesting to me, because I have we talked about this a little bit off the record. I used to, before I got into law and all this stuff, I actually used to do contract programming. It paid my way through school to a certain extent. And I'm wondering, it sounds very laborious to manually, in Microsoft Excel, keep track of warrant applications and outcomes, because I've looked at your data and it looks like you keep track of the application and the outcome.
Yes.
Do you still do it by hand?
Yes.
Have you guys talked to your IT department, somebody's IT department, to see about incorporating that kind of data mining into the overall program?
Absolutely, absolutely. We were just living on these two kind of legacy systems, knowing that the goal of the court was to move to a more robust case management system, a system that crossed over all litigation types. We had, I don't know, maybe 10, 12 different case management systems to track every different area of litigation. So that's why we've contracted with Tyler Technologies. So our new system will have all but civil, because we've contracted with another vendor for civil. eCourt will be the case management system for civil, but all the other areas of litigation, yes, will be all under one umbrella, and removal orders definitely is one. I will not have to continue to do spreadsheets.
So at some point, when this Tyler Technology gets their new package finished, you'll be able to actually go in and generate a report from the data that's maintained in that system to also cover these warrant issues. You'll be able to extract that.
Hopefully, that is our goal. We will have imaging, so we'll scan the documents in, and yes, we will have the actual documents and a register of action when it was filed. Yes.
I'll make it a lot
and the
easier
outcome.
for you. Yeah.
Yes.
Do you know roughly? I think you said that now you have a full-time person. Is it a full-time person that does?
Yes, a clerical assistant.
Okay, and she's full-time doing, or he is full-time doing the warrant tracking log?
The majority of her time is she does help us with the public counter, and she can do other things while she's waiting for the removal orders to be reviewed by our judicial officers and signed. She does other functions, but it really does require a good part of her day.
Okay, and that's basically every day?
Every day, because she then has to update our spreadsheet, right? They come back signed, and she's then reviewing them to update the outcomes. Correct.
Okay. So what's she going to do for a job once Tyler Technologies has incorporated all this into their database?
There's plenty. She can do some imaging and quality control of those documents. There'll still be data entry.
Yeah, okay, so the technology advancement isn't going to put her out of work.
No. They'll just be new jobs.
Right. Okay, going back to this data tracking, data logging, do you have any understanding of why it was? Well, first let me ask you, when was it that you guys first started tracking warrant applications for removal warrants?
I believe it's 2010 when it was sort of a pilot. We started receiving removal orders, and they were being assigned only to 2 judicial officers. And the volume was so low that it was manageable.
In fact, I think in January 2010, if I remember the statistics correctly, you only had 1.
Yes. Let me look at this data before I say yes.
Sure. I think it's at Exhibit A to your declaration, so it should be about
Oh, here it is.
6 pages in or so.
So yes, January we had 1 of 2010.
And then February it was 4.
Correct.
And we don't really see any larger numbers of warrant applications being generated till 2012, where it looks like you had a total of 2,230. Is that right?
Yeah. Yes.
Well, actually, this, I see. This filed is for the next year.
Yeah, it grows every year.
So like 2013 would be 4,199.
Yes, counsel.
Yeah, I was just looking at it. It was a little it confused me for a minute because one of the columns it looks like it trails on to the next page.
Yes, it's the size of the page.
Right. Do you have any understanding why it was that you were not tracking removal warrant applications prior to January 2010?
We weren't doing them prior to then.
I'm sorry?
I do not believe we were. That procedure or protocol was in place. We weren't receiving and processing removal orders.
Okay. In fact, that was one of the problems, wasn't it, that Judge Nash was attempting to address when he wrote his November 19th memo to the Department of Children and Family Services?
It seems so, yes, Counsel.
So is it your recollection? I mean, you were there, let's see, by, 2006, you were over at the juvenile court yourself as was it an admin one?
Correct.
Now, admin one, what sort of, is that a management position? What
It
sort of
is,
position?
Administrator 1. They just kept changing the names over time.
Okay, so as an administrator one, let's just say in 2006, what were your job duties? Just generally is fine.
I had an area of oversight over a clerical division of our operation, so I was over our appeals unit and our petition filing unit. And then the administrator at that time had 3 administrator ones, and he would divide our courtrooms by 3 of us. So I probably had oversight of, at that time, maybe 8 courtrooms, and the oversight was over the operational judicial assistants and the clerical assistants that supported that courtroom.
Okay,
for each of those courtrooms.
Just sort of structurally, in terms of the clerical administration of the business of the court, say we're in a particular courtroom, any papers that are coming into that courtroom necessarily are going to go through the clerical staff before they get to a judge. Is that right?
No, Counsel, not necessarily. The Department of Children and Family Services reports are submitted to the court directly. In juvenile dependency, there is a court officer / social worker that is assigned to that courtroom, and they would submit the reports to the judicial officer directly.
Those reports, they get a filed stamp on them, right?
Yes,
Who
and
affixes
it's
that?
usually after the hearing. If the hearing proceeded, then the judicial assistant would file stamp them and place them in the legal file.
Okay, so for example, if a petition's filed, I've seen hundreds and hundreds of these petitions, they all have filed stamps on them.
Are you talking
Like a
about
300
petition? Correct, and that comes directly into my staff. So that was the staff I oversaw in the clerical office, and yes, we would receive the petitions. We would file stamp them, process them, and assign them to the courtrooms.
Okay, and then the court reports that a social worker would file, if I'm understanding you correctly, if I'm not, tell me, explain it. What would happen is the social worker who's stationed in that particular courtroom would get the report, get that to the judge. If the hearing went forward, then that document somewhere would get a file stamp affixed to it.
Correct. The
Who
court
would do that?
The judicial assistant in that courtroom.
Okay, and then that judicial assistant, somewhere after the judicial assistant filed stamps it, where does the document go?
It gets placed inside the legal file,
Who has control over the legal file?
the court.
So there's actually, well, let's go back in time, because I think now you guys may have imaging, you may have different ways of doing it, I don't know, but...
Not in juvenile yet, but we will know. We have hard
don't?
copy. We have hard copies.
Oh, man,
We're getting there.
that's tough. So let's say 2006 to 2009, that time frame, after the judicial assistant in the courtroom, stamps it filed, will she or he have a physical file folder or something there that they
Always
put
the
it in?
legal file. Yes, that contains all the documents associated with that case, all the minute orders associated with that case. And so yes, they would then place it, hole punch it, place it under the ACO fastener in the legal file. They would complete their minute order, print it out, place that in the legal file. Any other documents submitted, there are a lot of documents that actually are submitted directly in the courtroom. And then when completed, they would mark the next court date, and that file would be, we maintain 90 days worth of cases in every courtroom. So if that case was coming back within 90 days, it would stay up in the courtroom. We have file cabinets. If it was going further than that, they would have to bring them down and file them in our records unit.
Okay, so when you said that you were responsible for 8 courtrooms, What does that mean? What was it that you were overseeing?
So the operational and administrative piece. So definitely I have oversight over the judicial assistant and the clerical assistant that prepares the calendars for the courtroom, pulls the files for the daily cases that are going to be heard, makes copies of calendars, that sort of thing. So that's the staff that I had oversight. And then and the clerical support that is offered, even in our clerk's office, that supports that courtroom.
Okay, so for example, when we're talking about the person who, at the end of the hearing, takes the report or motion, whatever may have been filed in the courtroom, that would have been the judicial assistant, right?
Correct.
And that person would have been under your management.
Correct.
Okay. And different managers have different management styles, obviously, but as part of your general management style, did you make it a point to have a pretty good understanding of what it was that your subordinate people were doing in the courtroom and how they were doing it?
Yes, that's part of my responsibilities, is to manage and mentor and train and develop staff. Absolutely be available. They have questions, procedural questions, definitely. And we, as an operation, we have regular meetings and meet with our staff to make sure that they are on top of any new changes or protocols or procedures that are changed, of course.
Okay, so back in that 2000, when did you get promoted?
2011.
2011, and you went then from a admin 1 to
An administrator 3.
So you skipped the 2?
Yes.
Okay, so let's just say from 2000, I guess we know there was a change. So let's start 2006 till the end of 2009. Your duties would have included oversight of the judicial assistants, the in-court clerical staff,
Yes.
right? And then
Yes.
also the people in records.
Not in records, in appeals and the petition filing unit. I had a colleague that was assigned to the records unit.
Okay. Let's just focus for a moment on the actual courtroom staff, the judicial and clerical. You already told me that part of your duties and process would be to mentor them and how to do their job properly.
Correct.
And then you'd have regular meetings with those staff of those 8 courtrooms to, I guess, reinforce the training that you were giving them?
Sure, and as an operation, we try to bring judicial assistants. So my colleagues and I would set up monthly meetings and have them all, so they're all hearing the same information, receiving the same training.
Okay, that way you get uniformity
Of
in
course,
the
yes.
practice.
Yes, and while I was assigned to just 8 courtrooms, if my colleague is out, there's an emergency, whatever, I really had to be able to step in and,
Yeah, pick it up.
pick it up, exactly.
Right, that makes sense. So the sorts of documents that your staff would be dealing with and seeing, this, particularly the judicial assistants, you had a pretty good familiarity with that?
Yes,
You sort of had to, because you're teaching them how to do it.
yes.
From 2006 until the end of 2009, then, you would have been familiar with, if there were warrant applications, things like that coming in, that's something that you would necessarily have had to have given your staff some mentoring or some training on?
Correct.
Okay, and did you do that?
No.
Is that because there were no removal warrant applications coming in, at least in your 8 courtrooms, between 2006 and the end of 2009?
Correct.
And these monthly meetings that you had, how many courtrooms total were there that were?
Today we have 22. I want to say at that time we were beginning to reduce, and we were doing layoffs. When I took over, that was when we were starting to downsize. I want to say we had 18 or 19 dependency courts at the children's court.
Okay, and your oversight responsibilities were just at the children's court, right?
At that time, yes.
Okay, now that may be something totally different.
Yeah, we have 2 satellite dependency courtrooms up in the Lancaster area.
Okay, but back then, 2006, 2009, your oversight responsibilities were just at Edelman's, right?
Correct.
Okay. and yet you had these monthly meetings. Did you have sort of a counterpart, somebody that was another admin one that was overseeing the other 10 courtrooms?
Yeah, at the time there were, I believe there were 3 administrator ones, and our dependency administrator, who we reported to, distributed the assignments, right? So we have an adoptions office as well, where the central adoptions, we do all the adoptions for Los Angeles Superior Court. We're the central operation for adoptions, non-dependency adoptions. Those are the independent step parent at that time. So yes, so he would direct us and say, I need you to have oversight over these areas, these supervisors.
Okay, so
in these
and
courtrooms.
you were telling me for consistency that, for example, if one of your counterparts was gone on a certain day or whatever, you would have to step in and pick up the management of their workload, right?
Sure, yes.
And I think you told me this, if you didn't correct me, that between management, you guys would meet and go over sort of the structure and the function of your total body of courtrooms.
Yes.
And that way, if somebody was missing, you would have still consistent management, one courtroom to the next.
Yes.
So you would have been in a position to know 2006 to 2009, going back to the warrant issue, even though we know that in your 8 courtrooms, you were there personally, there were no warrant applications being filed, but you would also know whether in the remaining 10 courtrooms there were applications being filed for removal warrants, because you would have to be applying consistently across all courtrooms in case somebody missed.
Correct.
Okay. So with respect to those other 10 courtrooms, between 2006 and 2009, were applications being filed for removal warrants?
No, sir.
Okay, so there was no...
To the best of my knowledge,
Sure.
no.
Sure, and I wouldn't expect you to, if you weren't working there and didn't have personal knowledge of it, I wouldn't expect you to know. But I think that we've kind of established, and if we haven't, correct me, but we've kind of established that just because of the nature of the work that you were doing with that oversight position and the drive, the necessity for consistency between courtrooms, you would have been in a position to know whether or not those removal warrant applications were coming through during that time period, right?
Yes.
Okay. And again, your testimony was that based on your experience, removal warrant applications were not being filed from at least 2006 to the end of 2009.
Correct.
Okay.
But I would like to just clarify, in 2009, even though I was not directly involved, I do know that there were some discussions of that they were going to be writing a policy or thinking about, because it was my colleague that was over the records unit where this removal order unit was going to be, but I believe there was, because I can't imagine that January 1 there had to be some discussions.
Some lead-in.
Right, as to how that process was going to be implemented, operationally at least on our end.
Do you know, and you may not know this, you may though, just because by virtue of being around, and like this example you just gave me where you kind of heard about something being in process before January 2010, do you know whether or not the County of Los Angeles was involved at all in that discussion about whether or not we should be getting warrants?
I do not know.
Okay. And how was it that you believe that you had some knowledge that something was in the works leading up to the 2010?
I believe there were some meetings that my colleague attended, and it might have been, and I did not attend, so I don't know, but I just remember him talking about.
And your colleague, who would that have been?
Reggie Papachan.
How do you spell his last name?
Pappachan.
I think I might have seen that name somewhere.
It's probably on something.
I'm not even sure if it's in this case. It just rings a bell. We've been going for about an hour. Why don't we take a little break? I'm going to refresh my coffee, and
Okay.
we can all get tea or whatever. Yeah, I'm trying to think that.
The time is 11:29 a.m. We're going off the record. Time is 11:42 a.m. We're back on the record.
Okay. In January of 2010, that was the first time that the juvenile court actually had specific assigned judicial officers to decide whether or not to grant removal warrants. Is that right?
Yes.
Okay. Prior to that, there was no judicial assignment. There was no judge assigned to deal with applications for removal warrants, right?
Correct.
And part of that, based on your experience there in management, was because nobody was seeking removal warrants.
To my knowledge, yes.
Okay. Now, we know from your statistics that in January 2010, there was at least one application for a removal warrant made and granted, right?
Correct.
Do you have any understanding how it was that the County Department of Children and Family Services learned from the court that there were now these two judicial officers available to rule on removal warrant applications?
Actually, I don't. It wasn't that I know through administration. It could have been through judicial staff. Yeah.
Okay. Do you know whether or not, if we look at, for example, Exhibit, hold on one second, Exhibit B to your declaration.
Yes.
If we look at Exhibit B, there's a memo here, and it's dated November 19th, 2010. You see that? It's in the upper quarter of the page or so.
I'm sorry, the November 19th?
Yeah.
Yes.
Do you know, for example, whether or not sometime before January 2010, a similar memo was drafted and delivered to the Department of Children and Family Services, letting them know that, number one, you need to start getting warrants, and number two, we now have two judicial officers assigned to process your warrant applications that you need to be making?
I've never seen one.
Okay. And when you were preparing for your person most knowledgeable testimony the last time we met, did you do any kind of search of the court files for, that sort of memo?
Yes, I did. I looked at files that my predecessor, Randall Henderson, who was the administrator, might have had. When he retired, he left me some folders and files of work, so I went through that. And I looked online. We have shared folder where any policies or procedures are, and the earliest document that I could find was the November 19th, 2010.
Okay. But clearly you would agree with me, wouldn't you, that if we had a warrant application filed in January that was granted, January of 2010, somehow the County of Los Angeles Department of Children and Family Services had to have known that there was this process in place?
Correct.
Okay. Do you have any understanding, like, how long before January 2010 that information would have been imparted to the Department of Children and Family Services?
No, counsel. I was not intimately involved at all in any meetings or anything.
Do you know, and you may not know, but do you know who we would want to talk to about that to find out?
I'm thinking that at that time, our presiding judge or our supervising judge would have had knowledge of.
And that would have been Judge Nash?
Judge Michael Nash was our presiding judge, and our supervising judge was Margaret Henry.
Is Margaret Henry still around there?
Well, now that you say that, she starts tomorrow. She is assigned back to our building. She was in delinquency for a year and a half in Pasadena. She's coming back starting tomorrow and opening our non-minor dependent court.
Okay, non-minor dependent. Okay, I understand.
So young adult.
Right. I'm used to dealing with the children's cases, and
Yes.
it took me a second to catch up non-minor dependent.
Yes.
So this November 19th letter, Exhibit B to your declaration. This is the earliest document that you could find that referenced the Judge Nash's communications with the county on the warrant issue.
Correct.
Okay. Do you have any understanding why it was? Because we look at the statistics, again, we're saying January 2010, we put this warrant process in place. We want the county to follow it. And then 11 months later, the court is writing to the county saying, hey, you need to start following our procedure.
I understand that in January we were receiving the removal orders and they were only being assigned to 2 judicial officers, and that this memo and procedures meant that we were now going to be assigning them to all the judicial officers because there had been some training and the review of the new procedures and the policy.
Okay. So at this point, November 2010, Judge Nash is letting the county know that, look, we're not just 2 judges anymore. Everybody's opened up. You need to start using this resource.
And that we actually have a procedure for this process, yes.
So we would expect then, wouldn't we, that there should be a significant uptick in warrant applications after November 2010, right?
I guess you could say that. I mean, I don't.
Well, if we look back to your statistics, that's at Exhibit A to your declaration. Let's look at 2011. Now, the data there, it looks like it only covers through April. So January, February, March, April, right?
For 2011?
Yeah.
So this memo was 2010 November. It was implemented. So then you're looking at 2011. Yes, I could only find data through April of 2011 for that year. And as you can see on the exhibit, I listed the missing data.
Yeah. Okay. After you spoke with us last time around, did you go back and undertake any effort to see if you couldn't find some of that missing data?
I did not after we met, but prior to you coming out, I did, because I prepared this stat sheet and I had my staff look.
Okay.
Yes.
How about since the time that we last met, have you gone back and tried to fill in that missing data?
No, counsel.
Okay.
I haven't.
Do you have any idea? Well, I guess probably you don't, because if you had, you would have produced it. But I guess since I'm halfway through the question, I might as well finish it anyway. Do you have any idea where a person might try looking to find that missing data?
Honestly, counsel, I looked at the log that the administrator at that time prepared, and he was the person actually receiving and processing them when this started in January, and I could not locate them.
When did he leave? And now when he left, you picked up his position, right?
Not Reggie Papachon. Reggie Papachon was my colleague, and he was the manager at the time in 2011 that was involved because it was under the records unit of the processing of the removal orders. When you came out last year, yes, he had been reassigned. I believe he was reassigned to another assignment in 2014.
Okay. All right. And prior to that, though, he was the one that would have been assembling this data?
Correct. Well, let me take a step back. I apologize.
Sure.
He had a log that he was writing down the removal orders in. I had a supervisor, when you were coming out, create the Excel spreadsheet, because instead of having a paper log, I thought we need to get on board with at least having the spreadsheet. And she updated the data for me, and now we use this log still.
Okay. Oh, well, I'm glad then. So our subpoena actually had an efficiency impact too.
Yes.
That's good. That's always what we hope for, is that, at least in some sense, we have a positive impact on, that's people we come in contact with. So that makes me happy. So I guess what's sort of confusing to me, and maybe you can clear this up, if you turn to Exhibit C to your declaration, we're a little bit like a year and a half later. It's March 2012 now. You see where I'm at?
Correct.
What is that document, that Exhibit C?
It was a revision to the original removal order process or procedure
Okay.
to this November 9th, 2010.
What I'm kind of wondering about is, it seems like he's telling the County Department of Children and Family Services, again, if we look right here at the first paragraph, he's explaining again that they need to be seeking warrants to remove children, removal warrants, instead of relying on the social worker's assessment of whether the child, is in need of removal. So what I'm wondering is, well, first, did I get that more or less right?
That's how I read it. I don't know his intent, and I was not involved in the development of this document.
Okay. But you did maintain the data, or somebody at the department did maintain the data.
We did maintain the data that was coming in, the removal orders, and the clerical process.
And I'm just sort of curious, is why was it that it was necessary, again in 2012, to let the county know that they really need to adhere to these warrant requirements and start getting or making warrant applications, if you know?
I don't know. The piece that I do know is I believed the process changed. With the increase of removal orders, I believe the first process, it first started with 2 judicial officers, then it went to all judicial officers, and they were being told, directed to file them directly in the courtroom, and it was getting a little procedurally unruly for us to be able to track where everything was. So I know some of our input was in the new version was to set up this whole new process of having them come to one person, let's log them in, and then let's get them up to the courtroom, and that way we could keep track.
Okay.
Since they were time-sensitive documents.
Right, that makes sense.
And there might be more to it from a legal perspective, but I don't have that knowledge.
Sure. In looking at, going back and looking at the 2010 data, the bottom of the filed granted rows, there's some numbers there, 265 under filed, 219 under granted. What's the significance of those numbers?
None for me, counsel. I must have been directed to keep track of what was granted or denied, and I think there's a recollection that before you came out, I think you may have asked if they were granted, denied, and I think that's how I set it up, because I believe our records were just tracking filed, how many that we get in, and that's why part of this creation was I had to have somebody go back and distinguish how many filed and then how many granted and denied.
So the layout of your Excel spreadsheet was driven in some respect by the nature of our request of data.
Correct.
You're swelling my ego up incredibly now, because you've told me that you still use the same spreadsheet
Yes.
to do the same tracking, and that makes me feel really good, because I had an even greater impact than I thought. So when we look at under the column that says denied, that 46, and we're still with 2010, am I correct that that number there represents the total number of removal warrant applications that were denied in 2010?
Correct.
and then
That the court received, processed.
and
yes.
denied, right. I'm going to sort of skip 2011 because if I'm understanding you correctly, there's a data anomaly there, and
Correct.
we really don't have an adequate statistic for, to do anything with. But going to 2012, I see that only April, data for only April is missing, right?
Yes.
And if we look at the totals, the 2230 for the filed, 2003 for the granted, and 227 denials. Is that what's represented down there to your understanding?
Yes, counsel.
Okay, proportionally, it looks like about 10% of the removal warrant applications were getting denied. Is that right?
You could say that, yes.
Okay, and then if we go back and compare that with 2010, what is that? About 20%, just roughly, 20% of the removal warrant applications were getting denied.
It looks like, correct.
So we can see a marked improvement in the process, or at least the reduction of denials from 2010 to 2012.
Correct. A reduction in denials, yes.
Yeah, percentage-wise, proportionally.
Proportionately to
Yeah.
the amount filed.
Right.
Yes.
Do you have any understanding why that might have happened?
No, not at all, counsel.
Okay. Do you know whether or not the court released any training materials or any further memos explaining to the Department of Children and Family Services why it was that the applications initially were being denied?
Not to my knowledge, counsel.
Okay, because we see, I mean, it's basically a 50% reduction rate in the denials between 2010 and 2012. We go from 20% denied to 10% denied, right?
I see that.
And you don't recall whether or not there was any further input from the court to sort of instruct the county procedurally if there was a procedural problem in the applications that was causing the denial.
No, counsel. Nothing that I was involved in at all,
Okay.
or that I have knowledge of.
And then if we go to 2014, we had a total of 4,870 removal warrant applications filed, and only 325 of those denied. Is that right?
That is correct.
So it's what is that, like 6-7% denied?
Correct.
So there's some continuing improvement going on there.
I don't know what you call I don't know what you mean by
Well,
improvement.
If we look proportionally, we start off about 20% of the warrant applications in 2010 are denied. We move forward a couple years and we've got it down to only 10% are denied. And now by 2014, we've got it down to somewhere between 6 and 7% are denied, right? It might even be less than that. It might be like 5%.
5%.
So I'm wondering, we see this improvement in the application process because they're getting more applications granted as opposed to denied, right? Proportionally.
I don't know if improvement. I'm not understanding like perspective.
Well,
I'm sorry.
it's okay. Let's just use
Whose perspective?
let's just use a mathematically simple example. Say we have 100 warrant applications one year, and 30% of those, so 30, are denied. And then something happens, I don't know what, the next year we have 100 warrant applications and only 20%, 20 of those are denied. A couple years into the process, still have 100 applications, only 5% are denied. You would agree with me that steady downward gradation of denials would indicate that there's something going on there to change the outcome, right? Whether it's an improvement in the process, training, whatever it is, there is clearly something going on there to cause that trend.
I see that there is a trend. I just don't know if it's a good thing or not, or it's meaning that the meaning behind it. I'm just not
I guess that's what I'm sort of getting at. Whether it's a good thing or a bad thing, whatever it is,
But there is a trend.
Yeah, you recognize a trend.
I see that.
Okay.
Based on the numbers.
Do you have any understanding from 2010 or any knowledge from 2010 to 2014 whether or not there was any communication between the court and the County of Los Angeles Department of Children and Family Services regarding this warrant process, other than the 2 memos that you've given us?
I do not, counsel.
Okay, do you know who would know?
Again, I am thinking our presiding judge at the time, our supervising judge would.
Okay. Let's see if there's anything else, and we may actually be done. Okay, just to clarify and make sure I've got this right, it is correct that the removal order warrant application process was first implemented by your court in January of 2010.
To the best of my knowledge, that you are correct.
Right. And we also already sort of went through this, but at that point in time, you were responsible, or prior to that point, up in 2009, say December, you were responsible for oversight of, I think, 8 courtrooms?
Around 8 courtrooms and clerical support of the appeals unit and petition filing unit.
And then based on your various meetings, staff meetings, trainings, things like that, you would have been in a position to know whether or not there was some removal order or removal warrant process in place, because you'd have had to train your staff on it.
I believe so, yes.
Okay. And you didn't have any training of your staff prior to January 2010?
That's correct, to the best of my knowledge.
Okay. And just to take care of some authentication issues, the document that we have attached as Exhibit A to your declaration, that spreadsheet, if I understood correctly, this is a spreadsheet that, correct me if I'm wrong, I think you told me that your staff generated at your direction?
Yes.
Okay. And as far as you understand it, the data depicted, the data depicted in this spreadsheet is, or at least was, true and accurate as of the time that you created the spreadsheet, with the exception, of course, of the missing data, which you've denoted on the spreadsheet itself as missing.
That's correct, counsel.
Okay. And then if we look at Exhibit B, that's the November 19th, 2000 letter from Judge Nash, or memo from Judge Nash to the Department of Children and Family Services. Am I correct that this is a true and accurate copy or depiction of the memo that was actually sent to the Department of Children and Family Services on November 19th, 2010?
Correct, and to the dependency judicial officers, yes.
Now, when we say dependency judicial officers, is that the dependency court judges?
Judges and commissioners, and at the time, referees.
Okay,
Yes.
so all that.
Yes.
Okay, so that whole group.
Correct.
Do you know whether or not there was a meeting between the judicial officers and representatives of the Department of Children and Family Services relative to this removal order procedure?
I am not aware of if there was or not.
Okay. That's something that maybe Judge Nash would know about?
Yes.
And then looking at Exhibit C to your declaration, that is the March 12th, 2012 memo from Judge Nash to the dependency judicial officers and Department of Children and Family Services, right?
Correct.
Is this a true and accurate depiction, true, accurate, and complete depiction of the memo that Judge Nash sent on March 12th, 2012 relative to the revised removal order procedure?
Yes.
Okay, and then I think the last one. The last one is Exhibit D to your declaration. It appears undated, and I'm wondering what that is.
I think these were our internal clerical instructions or procedure for processing the removal orders. And the first one, I believe, you have 2010, and we must have talked about 2010. That's when these instructions went out to our staff.
Okay, yeah, I see. Mine was stapled together, so I couldn't see the date in the upper right-hand corner. It looks like it's handwritten 2010.
Yeah, maybe I did that when
Okay.
when we met last time.
So this isn't something that would have been a procedure for the county social workers to follow. This would have been the court's internal procedure?
Correct.
Okay. And I guess that procedure changed at some point?
Yes, in 2014.
Okay, and that's depicted as Exhibit E to your declaration?
Correct.
And going back just for a moment to Exhibit D, is that a true, accurate, and complete depiction of the internal procedures for removal orders that was in effect in 2010?
Correct, yes.
Okay, and same question with respect to Exhibit number E to your declaration. Is that a true, accurate, and complete depiction of the internal procedures for removal orders that was in effect in 2014?
Correct.
Okay. And then the last exhibit is Exhibit F to your declaration. Do you recognize that as the original person most knowledgeable subpoena that was served on the juvenile court by my office back in, or on January 22nd, 2015?
Yes.
Okay. And if you can turn to page, I think it's actually page 3. It's demarked page 2 of 3, but it's actually page 3 of Exhibit F.
Yes.
And it's categories of requested documents about halfway down the page. You see that?
Yes.
And when you first agreed to meet with us and talk about this information, you undertook a diligent search to locate documents responsive to these, 11 requests?
Yes, counsel.
Okay, and you did produce to us all the documents that you found that were responsive?
Yes.
Okay, and those documents are included here as exhibits A through E to your
Yes.
declaration?
Yes.
Okay, and there are no other responsive documents that you know of?
Not to my knowledge.
All right, excellent. Thank you very much for coming out to talk to us today, and we will make every effort to make it so that you don't have to spend your time with us in court.
Thank you. I do. I greatly appreciate that. I
Yeah,
really
that way you
do.
can spend your time preparing for your trek instead of hanging out down in the courthouse.
It's okay. I'm there at Moss quite a bit. But
But I'll let you know I should know by April 14th as soon as I do know.
April 14th? Okay.
Yeah, because we have a pretrial hearing. That's our last pretrial hearing, and this issue is going to be addressed there. And so I will let you know as soon as we have any indication what the judge is going to have us do. That way you can prepare, or not. If it turns out positive, then I'll let you know that too.
Okay.
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 Again, I appreciate you coming
No,
out.
thank you. I
and,
really appreciate you accommodating my travel plans.
Sure, absolutely. If you have any issues, any questions, anything at all, feel free to shoot me an email, give me a call. I
Okay.
think you have my information.
I do.
And
Same thing if you need anything from me.
I appreciate it. So what do we do here as far as treatment of the transcript? Okay, let's go off the record.
Time is 12:12 p.m. We're going off the record, including DVD 1 and this deposition.